Well, good morning, good afternoon, and good evening to everybody. I'm Erin Daly. I'm the director of the Global Network for Human Rights and the Environment, a network of scholars, activists, and lawyers from around the world whose work lies at the intersection of human rights and environmental protection. I am delighted to welcome you today to the fourth in our series of webinars examining human rights strategies in climate litigation. Before we begin, I want to thank our wonderful panelists for lending their expertise and their experiences to this rich conversation. And of course, a great thanks goes out to everyone in the audience for joining us today and those of you who will be seeing the recording. We certainly hope that you enjoy this program. I also want to send a great big thanks and a virtual hug to Dave Valet of Widener University Delaware Law School for his tireless support and extraordinary commitment to this effort. Even during these times when travel is so restricted, this webinar series has allowed us to connect with people in all parts of the world to learn about regional particularities as we see the common challenges that tie us all together. In the best tradition of the GNHRE, this series has included the perspectives of both academics and activists and lawyers steeped in climate litigation, thus fostering an invaluable transboundary dialogue from which we can learn from the experiences of others and further strengthen our global network. We began in June with an icebreaker that introduced some of the most salient issues in this complex and dynamic field with experts from around the world. In July, we traveled to the Indian subcontinent and heard about the most important new trends in India, Nepal, Pakistan, and elsewhere in the region. Then in August, we visited Latin America and learned about recent developments in climate litigation from local, regional, and international perspectives. And today, now we turn our attention to Europe. In the coming months, we'll be in Africa and North America and in other parts of the world also. And recordings of all these webinars are available on our website at gnhre.org. But let us begin with Europe today, with today's program, where we'll hear from experts who have been in the trenches in climate litigation, from Ireland to Norway, and in some of the most important and groundbreaking cases in recent years, as well as pending litigation throughout the region. Let me begin by introducing our moderator, Margareta Wererinki Singh, who has organized this event. Margareta is Assistant Professor of Public International Law at Leiden University and the GNHRE Deputy Director for Europe. An expert in her own right in this field, Margareta's recent book, State Responsibility, Climate Change and Human Rights, explains where and when state action related to climate change may amount to a violation of human rights. She is currently working on a large project focusing on climate justice through the courts, which uses socio-legal research to investigate the effectiveness and potential drawbacks of right-based climate litigation. Margareta, the floor is yours.
Thank you so very much, Erin, and very many thanks to our panelists and to everybody who is here with us today for this fourth webinar in the GNHRE series on human rights and climate litigation. So today we have close to 1,500 climate change cases filed in courts and before quasi-judicial bodies around the world. Such cases have been filed in at least 33 different countries, as well as at the regional and the international level. And human rights have been increasingly invoked as legal ground for holding governments and sometimes private actors to account for addressing climate change or dealing with its adverse consequences. These rights-based climate cases have been the focus of this webinar series. And as Erin said, today, our voyage around the world will take us to Europe. So we are very privileged and fortunate to have a lineup of speakers who have been directly involved in some of the leading rights-based climate cases litigated in Europe. Our first speaker is Dennis van Berkel, a climate change lawyer based in Amsterdam, the Netherlands, who is legal counsel to the Urgenda Foundation and co-director of the Climate Litigation Network. Dennis will reflect on the stunning victories of the Urgenda Foundation and a group of Dutch citizens in challenging the Dutch government for not taking sufficiently ambitious climate action to reduce greenhouse gas emissions. Our second speaker is Dr. Rhoda Verheijen, an attorney since 2006 and partner at the firm Rechtsanwälte Günther since 2013. Rhoda is an environmental lawyer with many years of experience in international environmental law and policy. She wrote her PhD on climate change damages in international law and now works in her own law firm specialized in environmental planning and energy law in Hamburg, Germany. Rhoda's active cases include a case brought by a Peruvian house owner against a major energy utility, several cases against development consents and permits for coal power plants in Germany and Poland, as well as cases involving lignite mining permits and planning acts. She co-represents the People's Climate Case, a case brought by families in and outside the EU against the insufficient climate targets for 2030, and that's the case about which she will be talking today. And then finally, Louise Fournier is legal counsel, climate justice and liability at Greenpeace International, where she advises on Greenpeace's climate justice and liability strategies. She is an attorney registered in a New York bar and is based in Amsterdam. Louise will present a range of other innovative rights-based climate cases that are pending in France, Germany, Norway, Poland, and Switzerland. You will hear from these four speakers over the next hour or so. And after that, there will be a Q&A of approximately half an hour. Please post your questions in the chat box. My wonderful colleague, Jessica Miranda, will help make sure that your questions reach the panelists during the Q&A. So without further ado, I'll now give the floor to Dennis van Berkel to discuss the implications of the agenda case.
Thank you so much, Margaretha, and thank you, Aaron and Margaretha, for hosting this great series of lectures. I've followed some of the previous events, and I found them very enlightening and extremely interesting. So I'm also looking forward to this one. I will first provide you with a little bit of background on the agenda case, how the case made its way to the Supreme Court. I will go into the decision of the Supreme Court and how the Supreme Court dealt with the human rights obligations of the Netherlands with regards to climate change, and I'll make some general comments on interesting themes in the case that also can have implications for other cases. So very briefly on the background, the case was launched in 2013. And what the Agenda Foundation claimed was that the Netherlands was violating both its general duty of care under Dutch liability law, and it was violating its obligations under the European Convention on Human Rights, specifically Article 2, the right to life, and Article 8, the right to private life. Now, at the time in the Netherlands, there was no specific climate act. There was no specific target set for the Netherlands for 2020. The Netherlands was merely implementing its obligations under EU law, and its general projections were a reduction of 14 to 17% by 2020, compared to 1990 levels. Now, the general position of the Dutch state was that indeed climate change is a very serious problem, and that much more needed to happen. They agreed with us on the facts, but they said that action would only be effective if action were taken at the international level. In other words, the position of the Dutch state was, we won't act if others don't act. And secondly, there is no legal obligation, so you can't force us to act. What Urgenda claimed in the case was that the specific obligations on both bases were that the Dutch state needed to reduce its emissions by a minimum of 25 to 40% by 2020. And that was a number that has been central to the case. That number was derived, first proposed by the IPCC in its report in 2007, so it has a strong scientific basis, but moreover, it was also recognized by the Netherlands and other Annex 1 countries in the context of the UN Climate Convention negotiations as a necessary level for the developed countries, the Annex 1 countries, to keep emissions, to keep warming below 2 degrees. The case was prior to the Paris Agreement, so the case was argued on the basis of the 2-degree warming level. Now, that judgment was upheld by the Court of Appeal in 2018. However, the Court of Appeal based its entire judgment not on the duty of care under tort law, but on the human rights obligations under the European Convention on Human Rights. That judgment was then upheld by the Dutch Supreme Court in 2019, which confirmed the obligation of the Dutch state to reduce its emissions by a minimum of 25% by 2020 compared to 1990. Now, I will quickly take you through the argumentation of how the Dutch Supreme Court came to this decision. First, with regards to the obligations under Article 2 and on Article 8, the right to life and the right to private life, the Supreme Court referred to a case law of Strasbourg Court and concluded that in the event that there is a real and immediate risk, there is a positive duty to take reasonable and appropriate measures. Importantly, in the context of climate change, the Dutch Supreme Court concluded that these obligations are not only with regards to specific persons, but can also be with regards to large group of individuals or an entire state. Also, referring to case law on especially environmental hazards, the Dutch Supreme Court established that these positive obligations are also present in the case that the impacts are uncertain and may only arise somewhere in the future. Now, the Dutch Supreme Court then looked at the facts and came to an important part in the judgment, where it stated that if climate change were only a national problem, there would be no doubt whatsoever, looking at the threats of climate change, that there would be a positive obligation on the Dutch state to take reduction measures. So the question that was the central question then was, does the mere fact that climate change is caused by multiple states lead to the conclusion that that positive obligation is no longer present? So the Supreme Court then took an additional step in saying, looking at case law of the Strasbourg Court, where it defined the common ground method of interpreting the obligations of the Charter, and it looked at, amongst others, it looked at the UN Convention on Climate Change. It looked at the Paris Agreement, concluding that under those agreements, states have to do their part. It looked at the no harm principle, which according to the Supreme Court also emphasized this obligation and should be interpreted as holding an obligation for a country to do its part. And it looked at practice in both national and international private law, where in cases of where causers only cause, or entities only cause part of the damage, partial responsibility is established. So applying this common ground method that's employed by the Strasbourg court itself, looking at these different sources to interpret the precise scope of Article 2 and Article 8, the court then comes to the conclusion that under those articles, the Dutch state has an obligation to do its fair share of the total emission reductions. And with regards to this fair share, it also refers to the principle of common but differentiated responsibilities, on the basis of which developed countries specifically have to take the lead in reducing their emissions. The next question that the court then turns to is what this obligation, what the specific obligation is of the Dutch state on the basis of Article 2 and Article 8. And it then deals with the question, the balance of powers, this whole question of the division between the powers of the courts and politics on the one side and politics on the other side. And it states that principally establishing a reduction target, establishing the level of reduction is the task of politics. However, under the Dutch constitutional system, and this is not specific to the Dutch constitutional system, but the court says that it is the obligation of a court to, in the event that a positive obligation to act has been established, to then see what the lower limit of acceptable measures are that a state has to take in order to do its fair share to prevent dangerous climate change. And the Supreme Court also expresses this in the sense that it says, well, it cannot be the case that the state can do nothing. So although we accept that the precise reduction target is primarily something of politics, there must be a lower limit somewhere. It cannot be that this obligation that rests on the state is completely empty. It then concludes that the reduction target, the minimum reduction target that was previously already found by the district court, is indeed the lower limit of what can be required from the Dutch state. And the Supreme Court also analyzes, you can read in the text that implicitly it already finds that this is probably too low, but this was what the reduction target which was before the court, and the history of that, as I explained, it was in part because this case was filed before the Paris Agreement. Now, some more general comments and themes from the judgment. The first is the central role of Article 13 of the Convention, the right to an effective remedy. This played quite a significant role in the case. It both played a role with regards to the finding of partial responsibility, in the sense that the court came to the conclusion, if this were just a national problem, there would certainly be a responsibility for the Dutch state. And to give real effect to the convention, the court also referred to the right to an effective remedy as a basis to coming to the conclusion that there was an obligation to do its part. And secondly, Article 13 played an important role for the court in finding an obligation for the court to look for objective standards that could inform what the lower limit of emission reduction obligations are under the convention. The second theme, an important element of the case that I would like is the role of due diligence. And what the court found was that under Article 2 and under Article 8, there's an obligation for the state to act with due diligence, and that means specifically in the context of climate change, that there is an obligation on the state to substantiate that its policies and the measures that it is taken are sufficient in order to prevent the harm from happening. Specifically in the context of the Urgenda case, the court then also looked at the fact that despite the fact that the Dutch state said that it could still do its part to stay under 2 degrees while not reducing in the short term, the court concluded that the state did not provide any scientific proof. I think that the role of this due diligence obligation will also play a big role in future litigation, in the sense that the gap, on the one hand, the gap that is present between what is necessary in order to prevent dangerous climate change and the real actions that are taken is growing. At the same time, there is not a political recognition or a political of what individual countries should be doing, but this due diligence obligation that rests on the state also make that states will have to argue why their actions are in fact sufficient and are in fact reasonable and appropriate in order to do their part to prevent dangerous climate change. And that gets me to the last important topic, and that is, how will these specific obligations be defined in future cases? Now, as I mentioned, in the Dutch case, there was the political recognition that we used of the 25 to 40% target. That will likely not be there in future cases. But on the other hand, if you compare, there's a lot more scientific evidence both on the impacts and the severity of the impacts than there was there when the first judgment in 2015 was rendered. And the gap has been growing significantly. In other words, the urgency to act is even greater than when the judgment in 2015 was rendered. And I believe that therefore there is more scientific evidence and more objective standards that we as activists and lawyers can rely on to show that what the specific state is doing is not enough. And at the same time, I also think that it's important that we as a legal and activist community ask for these for the substantiation of whether what a country is doing is sufficient, to demand this also outside of the court, to demand this of our institutions, and also to work actively with scientists on defining what is the fair share of a country given the task that is at hand before us, and also specifically to ask this of the IPCC. The science presented by the IPCC has played a very big role in our case and in other cases. The next IPCC report is coming out, and I think it's important for us to, and scientists and lawyers, to ask of the IPCC in the context of their review rounds that they also present the science that can help us to identify the responsibilities of each individual state that we can also employ in the context of these types of proceedings. I will leave it at that, and I'm very much looking forward to the other presentations and the Q&As. Thank you very much.
Thank you so very much, Dennis, for that very rich and fascinating presentation. We will now turn to Dr. Rhoda Verheijen, who will discuss the human rights arguments formulated in the path-breaking People's Climate case before the Court of Justice of the European Union.
Hello, everyone. It's nice to be here. Hi, Dennis. Hello, everyone. Yeah, I have to admit that I didn't know that I was supposed to only speak about the PCC, Margareta. I'm really sorry, because I looked at actual 3 cases, because I thought it was especially interesting to actually compare the arguments in those 3. So I apologize if this is going too far. But I did submit my PowerPoint yesterday, so I'm, it's not entirely my fault. So yes, I should pick up the thread where Dennis left it. Essentially, I'm talking about 3 different cases today. One has been filed just very recently in February, which is the constitutional complaint. One has been filed in 2018, which is actually has finished, and the other is filed in 2018 and is ongoing. And you can, just from those cases and from looking at the agenda and all of the other cases, you can see the development in shaping and defining the standard of care in applying human rights arguments. So I will just try and walk you through these, if it lets me. Why doesn't it? There you go. So the duty to protect, as we all use it, it can be a duty of conduct or a duty of result. And I think that's really interesting to see how the duty of care or the duty to protect evolved in the agenda case, as we just heard it. And it's actually very important to note that the duty to protect under human rights law can often be a duty of conduct only and not a duty of result. So very often we don't ask for 20% or 40% or what have you not, or tons of carbon to be actually mitigated, but we're looking for conduct. So a standard which is more open and actually therefore feasible for the courts to actually deal with. And we'll see that in a minute. It's meant to limit and prevent harm and damage. Obviously, it's designed to define the boundaries between individual rights and state obligations. That's really important. We just heard about the margin of discretion. Where does it end? Is there one? And how do you actually weigh these issues in a concrete case when you look at a concrete state? And the practice, in my mind, currently struggles with the right temperature target, the share of the remaining carbon budget, as Dennis has just discussed. And as I see it currently, we're actually looking at what is the reduction pathway. And that's the latest approach that I've taken in the constitutional complaint. They are all feasible and I think legitimate attempts at defining the duty to protect. So Dennis was just saying the agenda case was based very much on different things, but was actually launched pre-Paris. So very many cases are now looking at the Paris Agreement or even looking at the Oslo Principles. But to be honest, many cases can't actually use the Paris Agreement directly because you can't rely on international law. So while using it to some degree, for one, I don't actually use it at all very much, the Paris Agreement as such, because I can't in Germany rely on international law per se. It's only a definition, an interpretive tool. You can define the share of the carbon budget by states on the basis of equity methods, IPCC. You can use the role of human rights per se in defining the share of the budget, per capita approaches. But the general problem, that's one I think this community has to turn to at some point, and I put this in front because I think it's important. The approach does not capture the actual carbon footprint of consumers and production of any country. And that is I don't know of one case that actually does this properly yet. So I'm turning to the PCC now, which is the European climate case. You see the plaintiffs here, some from Finland, some from Kenya. There's no picture from our plaintiff from Fiji. We're taking the European Union as an institution, as a lawmaker to court on the basis of the duty to protect, essentially. So the case was filed in July 2018. It's pending. We haven't spoken one single word about climate change. We're only speaking of and about admissibility and about whether or not we're actually allowed to go to the courts at all. We've received a negative judgment by the first instance court, which is the European Court in May last year, and we're since on appeal with the ECJ. And as of yet, we haven't talked about climate change or any legal standard or the duty to protect. This has to be made clear. So all I'm saying right now is based purely on what we've come up with as our application. So the duty to protect is the legal basis, the Charter of Fundamental Rights in this instance, the right to health and life, rights of children, the vocational rights and occupation, the right to property, and the right of equal treatment, which is actually a pretty new approach in there, which deals with generational equity. Obviously, this all is also based on the Treaty of the Functioning of the European Union, which is essentially, I don't know, the constitution of the European Union to some extent, to those of you who are not so familiar with European Union law. We also rely to some extent on the Paris Agreement, because in EU law, you can actually rely on international law directly. It is interpreted or enshrined directly. We look at the same principles essentially that Dennis has just listed there, and we use it to, first of all, to establish the need to act and to act quickly. What I haven't put down here is that we're also relying on Article 340, which is non-contractual liability. So to some extent, we've done the same thing as in the Ochenda judgment. We're looking at tort law, but mostly it's a nullification action. So the actual demand in the case is to nullify the three main greenhouse gas acts that set down an insufficient target of 40% until 2030. So the two approaches to define the duty to protect. Somebody is speaking. Never mind. The two approaches is, one is, we call it bottom up. So looking at what is possible in terms of technical and economic possibility of the EU. And one is top down, looking at the carbon budget as available when the allocation starts in 2021, in accordance with the legislation that we're actually challenging here. We can talk more about this, but essentially what this application does is it says the problem is so severe that everything that is technically and economically possible has to be done. It's actually, it's almost like President Obama. What you can do, you should do. And obviously it's much more complicated than that, but what it boils down to is essentially the European Union hasn't actually done what it could have done, and it hasn't actually even looked at what it could have done. And 40% is wholly inadequate on an objective level, and nobody's ever even contested this. So this case hasn't actually been decided on the merits, so I can't tell you what the court might have said. So I'm looking at the next case, which has actually been decided, so I find this very interesting to talk about. This is the German case that I brought in 2018, which was actually decided by the administrative court in Germany in 2019. And this was only about the national reduction target for 2020, so a little bit more similar to the Ochenda case. And we said that this is a binding and enforceable target and can be relied upon by the plaintiffs for standing. So it was essentially an enforcement case. Just keep to your promises and, you know, enforce the target as it is, because the 40% target in Germany was actually quite ambitious. And the German government in the spring of 2018 essentially abolished or abandoned it. And we requested the government to supplement the climate protection program to actually reach it. And we also asked the government to reduce CO2 emissions to a very specific extent, because we said, well, actually, this is your promise and you're only here. So you need to, you know, this comes down to 650 million tons. This made the case very concrete, and it also enabled us to actually not go against the legislator, but to actually make this into an enforcement case against the government. The secondary level argument, which was less at the center of this case, was the same argument that we just heard from Dennis, and that is also employed in the PCC, which is the duty of care on the basis of the duty to protect. So it's on the basis of our basic rights. We have a basic rights provision in our constitution. So we never directly use ECHR rights. We don't have to. And the main issue there was what Dennis just described as, where is the lower limit? What is the lower limit? And the court actually decided that there is a duty, that climate change is a matter of human rights, that actually people can go to court and ask for further protection. They decided that climate change issues are not something that cannot come to the courts at all, which is obviously one of the issues that we all face every day. And the court made it very clear that it was absolutely ready to decide about the lower level, but And that's like in the last half section of the judgment, it tells me, well, the lower level hasn't been, you know, it's not there yet. So the government is still doing something which might still be sufficient. So that's the outcome of this case. And I always say that it was kind of 90% won. But obviously it has ended, because when we started this case, there was no national climate law. And this shows how much all of these cases rely on national jurisprudence and legislation and the situation that you face, that you're faced with. So while the court actually allowed me to appeal, I couldn't, because the government and the legislature at the end in December 2019 enacted our federal climate law. So now we have a law, and that means that I can't do this kind of case anymore. So I'll skip this. So what we're doing now is we're going against this law, because again, the duty to protect is not fulfilled in the law. It enshrines the same targets which are too low. So this is the new complaint that we're now bringing, and I will talk a little bit about how I constructed the duty to protect in this case, because I think it's actually what's probably necessary now. Just to remind us, when Dennis launched Agenda, when I launched the German climate case, and when I launched the PCC, the 1.5 degree report was not out. So at this point, when we launched the constitutional complaint, the 1.5 degree report was out. So what did that mean? We were able to actually compare targets and concentration targets and temperature targets with human lives and human choices. So as Dennis said, the gap has become so clear and so huge that at this point, we decided that we could actually argue on the basis of Article 1, human dignity. That for me legally is a huge step. I would have thought that this was impossible 2 years ago, but based on the science that we then had in our hand and the prognosis that we had on our hand, it was almost, well, I mean, obviously it's necessary. I mean, when you have to read through all this, you just want to, I don't know, shriek or shout or I don't know what, but you know, when you represent people like the ones you see here, young people, the youngest is 15, this is about their choices. So the whole constitutional complaint is a very focused complaint against our national climate law. It has nothing to do with the Paris Agreement. This is about the right level of protection that has to be afforded by the German legislature to its citizens. So just very briefly about this, as I said, the German Climate Change Act of December 2019 is insufficient because the reduction pathway does not lead to or anywhere near 1.5 degrees. And even if the act might not preclude more climate protection, measures proposed and legislated do not lead toward 1.5, but well beyond 2. And you know, this is it's a document that is translated now into German. Everybody can essentially read it. But the argument is the guarantee of human dignity under our basic law is affected and actually infringed because a generation of the complainants is deprived of any options for action to protect itself, because you need to remain in control of the tipping points. And when we started writing this, I thought, well, this is too much. I can't confront the court with this. I mean, to be honest, I know there's 100 people, but I mean, the strategic considerations you give a case like that, you have to be able to actually argue this in court when you're in the hearing, right? And I actually think you can. And the problem obviously here is if you say that this isn't merely a matter of health or property or even life, but it is a matter of choices, you have no control anymore. And that's the language of the 1.5 degree report. You will not remain in control of your own life. Then this is directly to be argued under our Article 1 human dignity. That's a very strong right because there's no reservations in it. it can't be, how do you say, there's no exemptions to it. The legislator has to make sure that each generation has human and remains in possession of their own human dignity, which includes self-preservation and choices. So what happens during the legal argument then is obviously you have to develop again, what does that mean? You know, what does it mean? And given the gap and the fact that there is so little time left, the argument becomes very much, as I said before in the PCC case, a do as much as you can argument, weighed against everything else that you have to weigh against. And if you read the PCC application, so the European application and our application in this constitutional law case, you will see establishment of the right, how is it violated, and the weighing. So you have to weigh whatever you want the legislator to do against other people's rights and the state. So that's what we do there. And we argue much less with respect to percentages of something by whatever, but we're arguing on the basis of the new IPCC report and the new IPCC reduction pathways. I essentially say in this, I don't ask for any percentage by 2020 or 2030 or something like that. I'm asking the legislator to sit down and come up with a reduction pathway that is possible and that will actually protect enough, right? And that could be that could be a whole webinar of talking about what that means scientifically and legally. But I believe the argument is actually easier because, as I said in the beginning, and in most jurisdictions, I think a court can very rarely actually declare a percentage or a particular measure, but it can ask the legislator to do its work properly. And that's what we're trying to do here with the reduction pathway. Obviously, we are using Agenda very heavily. I've translated the whole of all of the judgments, which was a big job, into German for the Constitutional Court to read, because I believe that I'm actually using the same method, but on the basis of the new IPCC reports. So yeah, this is it. I think I've run past my 15 minutes. I'm open to questions, and I'm sorry if I've run into your presentation now, Louise. I'm very sorry. But I'll stop here, and you can mute me now, and I will stop my screen.
Thank you so very much, Rhoda. I think we all learned a lot from this very insightful presentation. I think you meant to say that the German constitutional complaint has been translated in English, so that's available to an international audience. Correct me if I'm wrong.
No, both the judgment and the application on the first German case and the constitutional complaint that's still ongoing are in English and are available publicly. And the PCC, of course, is also available.
Fantastic. Thank you so much, Rhoda. Then our final speaker is Louise Fournier, who will present a range of other innovative rights-based climate cases that are currently pending in courts in France, Germany, Norway, Holland, and Switzerland. Louise, the floor is yours.
Perfect. Hi, everyone. Very happy to be here with you today. I'm Louise Fournier. I'm the legal counsel for Greenpeace's Climate Justice and Liability Campaign. You can see my slides, correct? I cannot see. Okay, great. In Europe, Greenpeace entities have cases in various countries. There's a case in Norway for its allowing of drilling of oil in the Arctic. There's a case against France. There's a case against Austria for tax exemptions related to aviation sector. There's a case in Poland against coal utility PG&E. There's a case here in the Netherlands against Shell. And of course, Greenpeace entities are also supporting cases brought by the Senior Women in Switzerland and the Youth Climate Plaintiffs in Germany. And I'm part of the global team inside Greenpeace International that keeps an overview on these various legal strategies and help the development of these cases. But I have to start by saying that I am I owe a debt of gratitude to my colleagues in the various Greenpeace offices, their partners in civil society, and their lawyers, such as Rhoda here, who are really doing the work on a day-to-day basis. All right, so today, for the sake of this presentation, I'm going to be drawing from a few of these cases to highlight what I see are innovative uses of human rights law. So I'm also deviating a little bit from the presentation that I said I would do, but I think this is the most interesting, also looking at the time. So I'll be talking about two trends in which human rights law can advance climate litigation strategies, but also push the law. And then I'd like to engage in a discussion with this community of where do we go from here. So in terms of, human rights law pushing the law and being used to advance these climate litigation strategies, as we've heard from the excellent panelists, human rights law has been used in the past as a gap filler for multiple areas of law, whether that is humanitarian law, or of course, environmental law. And in the context of human rights litigation and climate litigation in Europe, I'd like to discuss with you two specific examples of where human rights law is pushing the boundaries of the law. The first one in introducing new legal principles, and the second one to hold specific actors and sectors accountable. So in terms of the first kind of trend that I see, the best example for this is the case in France, l'affaire du siècle, or the case of the century, which is a case brought by a coalition of NGOs led by Notre Affaire à tous, also with Fondation pour la Nature et l'Homme, Greenpeace France, and Oxfam France. It's a case that was launched in March 2019 by these four NGOs against the French government's failure to implement greenhouse gas emissions, as well as its failure to meet its own targets to reduce greenhouse gas emissions, increase renewable energy goals, and limit energy consumptions. And you'll see from the demands that it mirrors what Rhoda was saying in the German youth case. So they base these demands based on the government's general duties stemming from the French Charter for the Environment, which includes a right to a healthy environment, as well as very similar arguments that are inspired their agenda decision of Articles 2 and 8 of the European Convention of Human Rights, as well as what they argue is the general principle of law of the right to live in a sustainable climate system, which is what I would like to focus with you today, because this is what is innovative. So of course the plaintiffs, they recognize that this right to a sustainable climate system is not yet recognized by French law, but they base this novel legal theory on two main arguments. Firstly, they base it on text, whether that is text from the French Environmental Charter or from text from the international agreements, Stockholm Declaration, European Union law, etc. Text that indicates that one of the main goals of reducing greenhouse gas emissions is actually to guarantee that current and future generations have a sustainable climate that is conducive to human life. The second argument that they base this novel principle of law is the relationship that is increasingly recognized between a sustainable climate system and the enjoyment of human rights. And for this, they cite international human rights bodies, the UNFCCC, European Union law, but also multiple other cases, mainly the agenda decision, in which courts have pronounced on the link between guaranteeing a safe and stable climate and the enjoyment of human rights. So in the agenda decision, but also decisions in Pakistan and in Colombia. So taking those two arguments together, the NGOs argue that the fight against climate change is based on a general guarantee of a right to a sustainable climate, which is a prerequisite not only for sustainable development, but for the enjoyment of human rights for current and future generations. So here we see an example of plaintiffs using human rights law to justify a new general principle of law, in this case, the right to a sustainable climate system. And this is something that we've seen done in other jurisdictions as well, most particularly in the Juliana case in the United States. So in terms of next step, this case hasn't been heard yet, and will be heard either at the end of this year or next year. In terms of other uses of human rights law to push the boundaries of law, the second one aspect is holding specific actors and sectors that are the most responsible for the climate crisis accountable. And this is the case when we're talking about targeting the supply side of climate crisis, like in Norway, or for tackling the fossil fuel industry, whether that's in the Philippines or in Europe. So in terms of using human rights to close a supply side accountability gap, the best case example for this is the People versus Arctic Oil case that was brought by Greenpeace Nordic and Nature and Youth in October 2016 against the Norwegian government for its granting of new oil drilling licenses in the Arctic. And I think this answers one of the questions I saw, but in Norway, one of the main challenges around this case resolves around this scope 3 emissions, or the exported emissions. So Norway is one of the world's biggest exporters of greenhouse gas emissions. And the case aims to disrupt the fact that a major fossil fuel exporting country such as Norway can get away with a global perception of being a leader in the climate fight by enacting at home some climate relatively ambitious measures, while silently continuing to profit from feeding the world's addiction to fossil fuels. So in January 2020, the Norwegian Court of Appeal affirmed the lower court decision and ruled that the government had not infringed on the constitutional right to a healthy environment due to mainly judicial difference and margin of discretion arguments that we've heard already in this webinar. However, on the issue of exported emission, that's where the Court of Appeal disagreed with the first instance court. And it stated that in establishing whether the government has infringed on a human right, here in our case, the right to a healthy environment in the Constitution, all greenhouse gas emissions have to be taken into account. And for the Court of Appeal, Norway is responsible for these emissions after export because, one, there is a clear relationship between the production in Norway and the combustion abroad. And secondly, and importantly for this webinar, because human rights and the rights of future generations depend on it. So since then, in April this year, the Supreme Court has accepted to hear this case, which will be heard in November this year. And we'll see whether the Supreme Court will be the one that uses human rights to close the supply side accountability gap that we're seeing in climate action. And then the other trend in which we're seeing human rights law push the boundaries of the law is in the field of corporate accountability for climate change. We hear often, especially in Europe, about how climate litigation is mostly targeted against states, but there has been a lot of scientific evidence, especially by Richard Heady and the Union of Concerned Scientists, that show that actually there are 90 carbon producers that are responsible for almost 2/3 of all anthropogenic CO2 emissions between 1751 and 2017. So these so-called carbon majors, of which 47 of them, depending on mergers and acquisitions, 47 of them are investor-owned company, and they have contributed together to 21% of global emissions until 2017. So that is really huge. And in addition to this research, there's also a lot of evidence that is surfacing that reveals that the fossil fuel industry and these companies had early knowledge about the risks of their fossil fuel products. And instead of acting when they had the opportunity, they repeatedly not only failed to do so, but actively misled the public and regulators, and that they continue to do so nowadays through industry and trade groups. So it's therefore no surprise that complaints against corporations on the basis of human rights arguments have emerged, and I believe that they will continue to be more and more of those. And then one of the most important such complaint is the one that was brought in the Philippines. Why am I talking about proceedings in the Philippines when we're in a webinar about European human rights strategies? I think for three reasons. I think we all agree, climate change goes beyond borders, but also because these corporations, a lot of them are domiciled in European countries. And when the resolution comes out in this inquiry hearing, it will have repercussions in Europe as well. And then thirdly, because I believe that as lawyers and campaigners and academics that are working in Europe, we also have a duty to consider what's the impacts of our cases outside of Europe. So coming back to this complaint, it happened in 2015, after 2 years after a super typhoon devastated the Philippines. It was a group of Filipino citizens and NGOs, including Greenpeace Southeast Asia, who submitted a petition to the Commission on Human Rights of the Philippines to hold a national inquiry for the responsibility of the world's largest carbon polluters in human rights violations resulting from the impacts of climate change, such as typhoons. So this is really an example of where human rights law, particularly the UN guiding principles on business and human rights, have been used to articulate the concrete responsibilities of fossil fuel companies to prevent and redress the impacts of climate change. Last year, the Commission on Human Rights concluded its national inquiry after 12 hearings in Manila, but also in New York and London. And the petitioners anticipate and hope that the Commission will release the resolution this year. And in terms of impact, this is the first ever climate change related complaint that was submitted to a National Human Rights Commission that looked at the responsibility of corporate actors that are headquartered outside of the state where this complaint was brought. So just for this case, just for this fact alone, it is already groundbreaking. In addition, all the materials and evidence and expert witnesses that have been heard during the inquiry hearings, all this material is available online and can serve as good repository of information for future litigants to look into. And then of course, a positive resolution for the petitioners, which we're hoping for, will really be absolutely groundbreaking, not only in the Philippines, but also here in Europe, and could even serve as basis for national human rights litigation against these carbon majors. And one of such example is the case against Shell here in the Netherlands. So Greenpeace Netherlands, along with Milieu Defensie and 5 other NGOs and around 1,700 citizens, launched in April 2019 a lawsuit against Royal Dutch Shell, arguing that Shell's contributions to climate change violate its duty of care under Dutch law and human rights obligations. So you see the parallels and the very clear reference to the Agenda decision, and the case was really built on this. It extended the arguments that were made in the Agenda decision to private companies, and arguing that Shell has a duty to align its greenhouse gas emissions targets or currently ambitions with the Paris Agreement and the best available science. It also builds on the inquiry hearings in the Philippines, as it's a lot of the same science and a lot of the same expert witnesses. All this to state that Shell is unlawfully endangering Dutch citizens, and its actions constitute hazardous negligence under tort law, but also under tort law as informed by Articles 2 and 8. So we hope that the outcomes of the inquiry hearing in the Philippines will have an impact in the Shell case, as well as in cases, in future cases for corporate accountability based on human rights in Europe. So I had to go really quickly, but I hope that you allow me some quick reflections on where do we go from here. I've shared with you some example of how human rights arguments are used to push the limits of the law and the benefits of it. But beyond these tactics based on human rights, where do we go from here? How do we ensure that we use human rights law argument to reflect an intersectional approach. If there's anything that COVID and the climate crisis have in common, is that they reveal very quickly the systemic injustices that we have in our societies. So when we're developing these human rights arguments, are we considering these impacts that on vulnerable population in our countries? And are we considering the impacts of the demands that we're asking outside of Europe? So the second question that I'd like to reflect with you all is a question about approach. So when we're working on these climate cases that are based on human rights, how are we making sure that we're building power with these communities? Are we building unrealistic expectations? We know that the climate crisis has really deep structural roots that cannot simply be litigated away. And are we pinning success on success that is happening in court? Are we ensuring that we're building this from a space of long-term collaboration and humilities as the legal advocates? I think all of the panelists would agree here that it's important to remember that climate litigation is more than obtaining a judgment in court. It's also a part of a larger process in which human rights law is a tool towards achieving the objective of actually building power to ensure lasting change. So I had to go pretty quickly, but I'm really keen to hear your thoughts and answer your questions and discuss with the other panelists. We have some resources. So we have Greenpeace Southeast Asia has a guide on human rights litigation towards governments. There's also the link to the evidence that was submitted in the Philippines. We have obviously Twitter that you can follow us. And then just lastly, in terms of upcoming moments, I didn't have a chance to discuss today, but we have the senior Swiss woman case in Switzerland where they are contesting the inaction of the Swiss government. It's very similar to Rwanda decision and other cases of inaction of the government. And this case has exhausted all domestic remedies in Switzerland, meaning that they lost at every instance. But it also means that it might be one of the first cases that reached a European Court of Human Rights that has exhausted all domestic remedies. And the senior Swiss woman and the legal team and myself, we're working right now on this application. So this is something to watch. The deadline is January next year, but it will probably be filed much earlier. And then of course, keep an eye out for the resolution by the Commission on Human Rights in the Philippines, the court hearings in Norway, and the public court hearings in the case against Shell. So thank you.
Thank you so very much, Louise, for this fantastic presentation.